Hello respected viewers, welcome back to my English Law channel. So this lesson is going to be about legal writing, so how to respond to questions in exams. So there are problem questions in exams, there are essay questions in exams, and so I'm going to tell you what would make an excellent answer and what are the mistakes that people often make, so how to evade these pitfalls. So you probably know a little bit about legal writing skills already, and hopefully have amassed quite a compendious knowledge of English law by this stage, especially if you've watched all the videos from the beginning, scores of them now. Anyway, so obviously you've got to be writing in formal English, ought to go without saying. So the problem questions, people often recommend that you write a plan first of all. I used to underline or circle words. These are the key words. These are things going to come up as I'm brainstorming, jotting down a short form of various cases to mention or principles that I need to bring up. And so you'll see the issues that need to be addressed, and then you'll deal with them one by one. Okay. So say, well, what's the issue here? And what's the doubt? And every detail is significant. Why did they say that? Why did they say this item costs £5,500? It's only just a bit over 5,000. Does that make a difference to the law? And does it matter that this contract was accepted over telephone or in writing? Why have they put that in? They've not put it in for no reason at all. They've said this person is 17. Why are they telling us the age? Something's got to matter about that, or things like that. Okay, so got to see whether things are valid, are things done the correct way, are things communicated, and so forth. Is there any doubt? The thing is, as you'll find out in law, things are seldom crystal clear. It's rare you can say definitely. Quite often you're saying probably and possibly. So one of the principles people say to remember in writing answers to legal questions is Iraq. No, not the country, not spelled like the country. IRAC, Iraq. Now why? So go look at issue, rule, analysis, conclusion. So go through those four things in order. Issue, rule, analysis, conclusion. So what are the issues we're dealing with here in this problem question? And then what rules need to be applied, and analyze situation and draw your conclusion. Okay, so citing cases as you go: Partridge against Crittenden, or Dowden against Stack, or Beswick against Beswick, or whatever it is, Carlisle and Carbolic Smokeball, and so forth. Store against Manchester City Council. Okay, so these problem questions will often focus on a particular aspect of law, and it's going to require a fairly profound knowledge of it. So the idea is you select this one if you're confident that you know the law on that issue. Otherwise, try to find another one. And if there are no questions where you know a great deal, well, then you're in trouble. But you've got to make the best of a bad bunch if it comes to that. Anyway, so reread your stuff. Are there any mistakes? Is there anything you left out? If your handwriting, I used to write on alternate lines and be able to fill things in. If at the end of that, oh yeah, I missed that bit, rather than trying to squeeze in the gap between two lines, or oh, my handwriting wasn't very clear then, can I reshape that letter, just cross the word out, write again, something like that. So you want to cite cases, academics, articles, judges, and so forth, and then voice an opinion towards the end. So it's going to be analytical rather than narrative, your approach. Okay, so a good answer would obviously be sound legal knowledge, would be articulacy, would be there. That would characterize the answer, articulacy. It'd be aptly structured, following the Iraq principle, and it'd be ample. You would have written enough. You could trade off between quality and quantity. All right. When we say a clear answer, it doesn't have to be a decisive answer. It doesn't have to be a definite yes or no. It might be a definite yes or no, but we could be coming down somewhere in the middle, because that might be the opposite answer if the law is developmental and uncertain on this issue. So yeah, say a few minutes writing down some key points, just buzzwords at the beginning, and then just address the core issues at the beginning to make sure you've done them, and the examiner knows that. The examiner thinks, oh right, he's got the right idea. or she knows these are the most important issues and the least important ones a bit later on. Also, making sure you don't forget the most important ones, you got them in there straight away. Okay, so if it all goes wrong, if you mismanage the timing, I would just go to bullet points and not write full sentences. That is not ideal, but that's better than not finishing. Okay, remember the Iraq principle. If you can think of any pertinent authorities or cases for each one, that would be splendid. And ideally, if you could put the date of the decision. I mean, they're not going to have to say, I'm not going to say it was All England Law Reports or whatever. You don't have to do a full proper case citation. So what are the frequently made mistakes that we're going to sidestep? Sometimes just being too brief, being too imprecise, not citing any cases, not actually saying what the issues are, not having a conclusion, writing in a colloquial style, things like that. Okay, so you got to have authorities there, and you've got to prove your knowledge. The examiner can't assume that you know things. Okay, so what else do we want here? Yeah, addressing all the details. Why with all these particulars mentioned in the case? All right. So, anything else? Well, that's about it, really. And you can see examples of good pieces of work and bad pieces of work. So please follow my channel. Toodaloo.